That way it takes all the liability off of you guys, takes it off the city. I think it'll be the best thing to do.
Sounds good to me.
Okay.
Tell the doctor.
Put me in handcuffs.
Turn around, put your hands behind your back.
What have I done?
Put down the damn phone. You're calling 911. We're standing right in front of you.
But I'm
Does that
asking
make
you to
sense?
leave my residency.
I'm not leaving your place now. Cuffs wouldn't be on you if you weren't acting the way you are.
Whatever. Acting by exercising my constitutional
Okay, have a seat. The worst thing you could do is make a 911 call right in front of us. Actually, what you did was against the law.
It's not against the law.
How much time do you have on?
20.
I have 34. So the smartest thing's going to be put him on a gurney, handcuff him to the rails, take him to the hospital, tell the doctor that he's complaining that he's got previous back injuries and he fell in comfortable position and you need to clear him. That way it takes all the liability off of you guys, takes it off the city. I think it'll be the best thing to do.
Sounds good to me.
Okay.
So we're on the same page. Information?
This case stems from a harrowing 2019 incident in which veteran advocate Slade Douglas was falsely arrested, sexually abused, tortured, and forcibly hospitalized by LAPD officers Jeremy R. Wheeler and Jeffrey H. Yabana. In October 2023, United States District Judge Honorable Maame Iwusi Mensah Frimpong rejected an appeal from LAPD lawyers to dismiss the case, ruling that officers Jeremy Wheeler and Jeffrey Yabana are not entitled to qualified immunity for unconstitutional detention, excessive force, retaliation, violation of due process, violation of the Americans with Disabilities Act, violation of the Bain Act, battery, false arrest, false imprisonment, and negligence. The judge also held that the city of Los Angeles is vicariously liable for the officers' actions. Slade Douglas was unjustly targeted for a wellness check and labeled a threat after he filed a systemic discrimination complaint against the Veterans Administration. Following his formal complaint to the President of the United States, the Veterans Crisis Line, VCL, contacted him. Douglas then reached out to the VCL regarding his systemic discrimination complaint, which is currently being monitored by the United States House Committee on Oversight and Reform.
The VA employee, Rhonda Meeks, became very upset and was openly hostile to my claims of discrimination. She asked if I was suicidal, and I responded, no. It's racist to ask a black man if he is suicidal because he is complaining about discrimination. Meeks then remarked, all black veterans think they're being discriminated against. When she became verbally abusive, I informed her that I would be ending the call. She immediately called back, continuing her tirade, calling me delusional and insisting that I was not being discriminated against. I told her I would be filing a complaint against her and ended the call. Approximately an hour later, the LAPD was at my door.
Official Veterans Administration documents reveal that on August 27, 2019, the VA initiated a swatting incident against Slade Douglas, falsely summoning the LAPD to his location. The National Archives and Records Administration later disclosed that the VCL intentionally deleted phone calls from that day, which contained false suicide allegations against Douglas.
The ease with which a wellness check or swatting can be initiated, requiring only a person's name and address, creates a precarious situation where no one is safe from abuse. And LAPD's systemic, deadly practice of criminalizing wellness checks often leads to unnecessary use of force, with individuals being fatally shot or harmed.
2 men were charged with orchestrating a swatting scheme targeting dozens of public figures, including members of Congress. The defendants made false emergency calls, leading to armed police responses at the victims' residences. The indictment alleges that between December 2020 and January 2024, Szabo and Radovanovic conspired to make false emergency calls, leading to armed police responses at the residences of their victims. Their actions reportedly targeted 61 public officials, including members of the House and Senate, executive branch officials, senior federal law enforcement officers, and state officials, and 40 private individuals. U.S. Attorney Matthew Graves emphasized the severity of swatting, stating that it endangers real people, wastes precious police resources, and inflicts significant emotional trauma. Slade Douglas, an Army veteran with an impeccable record, accomplished athlete, holder of multiple black belts, former Golden Gloves boxer, former law enforcement officer, and college graduate with multiple degrees, including a Bachelor of Science from Florida State University, has lived a life of both remarkable achievements and heartbreaking sacrifice. As a first-year walk-on at Florida State University, Slade defied the odds, quickly becoming a standout athlete. His blazing 4.1-second 40-yard dash and electrifying performances earned him a feature in ESPN The Magazine as the defending national champion's new weapon.
Gardner and Slade Douglas are back.
He capped his first season as the starting kick returner in the national championship game, a feat even more incredible given a 5-year hiatus from football during his military service. But the unseen scars of untreated PTSD from his service forced Slade to make the painful decision to step away after just one season. Even so, his immense talent was undeniable. NFL teams, including the New York Giants, expressed interest in him as their starting return specialist. Sadly, his sacrifices for his country ultimately cost him these opportunities. The community caretaking doctrine, welfare check justification, does not apply in private homes, as clarified by Caniglia v. Strom, 2021. The officer's request for consent to enter unequivocally confirms that they recognized no ongoing emergency, thereby ending the community caretaking function and requiring a warrant for any further action. Judge Maame Yawusi Mensah Frimpong set a precedent in the case of Slade Douglas versus City of Los Angeles et al., where she declared, the purpose of a welfare check is for the benefit of the individual at issue, not because they are under suspicion of any crime.
Hi, Doug?
Douglas.
Mr. Slade.
Yes.
How you doing?
All right.
We got a call from, was it the veterans?
I don't know what they called for.
Can we come in and talk to you for a minute?
Yeah.
Okay. Is there anyone else in the house?
No, just me.
Okay. So, I'm just gonna make sure nobody else is
No,
in there.
please. No. Hold on. I asked you no.
All right.
The officers did not inform me of the scope or purpose of their entry. I consented only because I believed they were there for a different reason. Specifically, the officer stated, "We got a call from the veterans," to which I responded that I did not know why they called. Yabana then added, "Can we come in and talk to you for a minute?" Had I known their true purpose, I would not have consented. The officer's vague and misleading statements such as, "We got a call from the veterans," and "Can we come in and talk to you for a minute?" failed to disclose their actual purpose and obscured the true intent of their entry. Any reasonable person in my position would not have understood this to be a welfare check. Courts have held that consent attained under such circumstances through deception, coercion, or failure to disclose relevant facts lacks the voluntariness required under the Fourth Amendment. See Bumper v. North Carolina. Without informed and voluntarily consent, the officer's entry was unlawful. The Fourth Amendment protects the sanctuary of the home, and warrantless entry is presumably unreasonable unless supported by informed consent. By failing to secure such consent, the officers violated my Fourth Amendment rights. See Johnson v. United States.
I'm gonna have to ask you to leave, because this is my house.
Okay.
Number one, and you just can't walk around.
Let me ask you just a couple questions. Okay. The veterans people, they were concerned, okay, regarding a couple things. One was which that you were threatening to commit suicide.
That's not true.
Okay. So what I'm here for is just to make sure you're not going to do something like that. You understand? So if you need our help, that's what I'm here for.
I'm okay.
So we're not here to mess with you, bother you, or anything.
Well, you do understand if you just walk in my place and you just automatically start walking around, and I know y'all wear body cams as well. I'm extra enforcement too. If you just come in my place like that and you just start walking around, you have to have my permission to do that. So I don't appreciate that. You can't violate my rights because you got a call to help.
Okay.
So you're not helping me if you just come in and you automatically start violating.
Well, sir, it was more for like officer safety.
No,
That's all
it's
it
not
was.
officer safety because I didn't even have to let you in.
Right.
Why the exigent circumstances defense fails. The officers cannot retroactively claim exigent circumstances to justify their warrantless arrest because they created the situation. By entering the home under false pretenses, the officers manufactured the conditions leading to the arrest. Courts do not permit police to rely on exigent circumstances they themselves created. Kentucky v. King. Unconstitutional entry invalidates all subsequent actions. The arrest stems directly from their unlawful entry, making it a fruit of the poisonous tree and inadmissible under Wong Sun v. United States.
Don't say right, because it's about my safety, because you're in my domain, and if you're here to help me, you can't say, well, my safety is, because I have no weapons.
We don't know that.
You do know that, because I'm asking you to leave. Please leave. I'm asking you
So
to leave.
you don't feel like hurting yourself?
I'm asking you to leave.
You don't feel like hurting
leave.
yourself?
I'm asking you to leave my residence.
After the unconstitutional entry, the officers made a warrantless arrest. Under Payton v. New York, a warrantless arrest inside a home is unconstitutional unless the officers witness a crime in process. There is a valid warrant for the arrest. In my case, the officers had neither valid consent to enter nor witness criminal activity, making the arrest unconstitutional.
Well, if you answer this question, then we'll
I'm asking you to leave my residence.
I'm about to put you in handcuffs, sir.
If you do that, that's your choice.
Okay, turn around. Put your hands
Why
behind
would you put me in handcuffs?
Turn around, put your hands behind your back.
What have I done?
You're going to listen to what I said. You're going to put down the phone. You're calling 911, and I'm standing right here.
But what have I done?
Put down the damn phone.
Why are you
Turn
cursing
around,
at
put
me?
your hands
Why
behind
are
your
you
back.
using profanity
Put your
at
hands
me?
behind your back.
Why are you using...
Because you know what? You're calling 911. We're standing right in front of you.
But I'm asking you to leave my residence.
I'm not leaving your place now. Turn around, put
You
your hands
said you
behind
came
your
here to
back.
help
I'm not
me.
doing that now.
All right, sir.
Put your hands behind your back. You're calling 911 right in front of us.
Because I asked you to leave my residence.
We can't leave
You know
until we
this.
determined.
You know this. You know exactly what I'm talking about.
No,
If you were law
I have
enforcement, then
rights.
you would understand.
Okay. And this is why African Americans have issues with law
Don't start
enforcement
that.
as well.
Don't start that. That's a bunch of
I
nonsense.
asked you to leave, and you used profanity at someone?
That's okay. I could use that.
Oh, really?
if I
For
want,
someone
yes.
who you concerned about
Yes.
doing something to themselves?
Hey, you know what? When you're not listening to commands, what did you do?
That wasn't a command.
All right.
A command for me to ask you to leave my residency?
You don't command us to do
I can
anything.
ask you to leave if you're not supposed. Why are you here? You were here to help me, and
We are here because somebody wanted us to check on you.
and I told you I was fine. And then you started exacerbating my condition.
You
Why are
need-
you putting your hand up like for me not to speak? You can't help a person if you don't want to listen to what they are saying. If I ask you to leave because you're exacerbating my disability, which clearly you're aware I'm a person with a disability because you already observed, number one, you see a sign right here that's saying that. Number two,
How do I know what that is?
Yeah. What is that?
oh, well, how do you
How do you know I don't have one?
You could, but guess what? If you had one and you came in my residency and I
So
came,
you're,
hold on
you're
one
the
second.
victim here, right? You're the victim here, right?
Well, you guys are victimizing me, and now I'm in cuffs.
Well, you're in cuffs now because of the way you're acting.
Why? I asked
Who
you
else
not
is
to
here?
touch my plate.
Don't-
Why are you grabbing me? I'm not doing anything.
Relax.
I'm in
Because he
cuffs.
sets to stay
Relax.
But
right
I asked you not to look around my
Relax.
place. Okay, that's a violation.
Hey.
What are you doing?
Stand right there.
I can move.
No, you cannot.
Why not?
Because you are in our custody right now. You are being
Okay.
detained.
Okay. I'm being. Okay.
You know what? You could call up whoever you talk to and tell them, explain to them.
Sir, would you please
why
not
we're
step
here.
on my rug, please? That's a very expensive rug.
Who says I want to step on your rug?
You why are you acting like
These your
this?
shoes?
See, yes, they are.
Okay, good. You can put them on. You have ID with you?
I do, but I need to get it. I can't get it.
Where's your ID?
Would you please remove your hands off of me?
No, I will not.
I'm not resisting.
No, I will not.
I
I will not. And I recommend you don't resist. So put your shoes on.
Why would I resist so y'all can
Good.
put my
Hands on.
That's what y'all want to do anyhow.
What's
Where's
your
your
problem?
You?
You know what? We came here because you called for help.
I didn't call you. I didn't call you.
Who did you call?
I did not call you.
Who did you call?
I didn't call
Who do
you.
you think they're gonna call?
I don't know. Obviously, I wouldn't want them to call you all.
Well, they did.
Okay.
Okay.
Well,
And now you're in our custody because you're under a mental evaluation.
That's
Okay.
funny. Okay. I'm glad, and the body cams are working too.
Absolutely.
Okay, good.
Absolutely.
Where's your ID?
Do you want your ID?
I can't get it because then I'm not going to allow you to go through my things.
Okay. So you don't own any weapons.
I already showed you that I had no weapons.
I don't know
and I told
that.
you that.
I don't know that.
Okay, you don't know anything.
Because I could go looking for anywhere that you might have a weapon if you're going on a 5150 hold.
I shouldn't be on a 5150 hold.
Why don't you?
That's an abuse of authority to put someone on a 5150 hold who has shown no signs of harming themselves.
The officer's arrest for calling 911 was unlawful, violating California Penal Code 591, and amounts to obstruction of justice under 18 U.S.C. 1512. Additionally, after revoking consent by asking the officers to leave 7 times, their refusal to leave violated my Fourth Amendment rights under Florida versus Ward and Snicklock versus Bustamante. Their continued presence also constituted a violation of 18 U.S.C. 242, which prohibits the deprivation of rights under color of law.
Judge Maame Iwusi Mensah Frimpong noted that the defendants concede that Douglas was engaged in protected speech when he contacted 911 in their presence, further stating that it is unconstitutional to evoke probable cause to take someone into custody under WIC 5150. Judge Frimpong also added, as an initial matter, the court finds it well established that it would be a violation of constitutional rights to apply any force when there is no probable cause that the individual has done anything illegal or threatening.
What's his condition? His arm is exasperated?
In the back of a patrol car, hands bound in cuffs, Douglas cried out in pain, but his cries were met with laughter. The officers mocked his disability, dismissing his suffering as they stripped him of his dignity. The court noted, it is well established that any force applied without probable cause is a violation of constitutional rights. And yet, Douglas was subjected to force, humiliation, and dehumanization, all under the guise of protection.
You spoke to Alicia. Alicia called us.
I don't know anyone.
You were speaking to her from the VA.
Anyone named Alicia. That has nothing to do with her action.
Okay. He said he did call them, but he did not threaten to commit suicide. I actually tried to call them and wasn't able to reach her. I mean, that's probably a huge, huge bureaucaucy. You're in custody because you're under a mental evaluation.
From who?
From us.
You don't have authority to put someone.
When the VA calls us, yes we do.
You said because I called.
Yes we do.
However, here, the officers had no such extensive nor detailed information. Rather, there were no details other than a second-hand communication from the Veterans Crisis Hotline reflecting that Douglas stated he was considering committing suicide without any context. Moreover, the officers did not talk to Alicia prior to meeting with Douglas and only attempted to get in touch with her after they had already taken Douglas into custody.
Okay, so got a call from the VA. Apparently this guy threatened to commit suicide over the phone. Then I hung up the phone, so it generated a call with the VA called us. Get out here, we get up to the apartment. He's in there. He opens the door for us. He actually lets us in. After a few minutes, start just checking, make sure nobody else is in there. We handcuff him because he immediately gets irate, starts calling 911 on his phone because now he's asking us to leave, but it's like at that point I'm already there, so put him in handcuffs.
This is our supervisor.
Hey, how's it going, sir?
It's not going well.
It's Sergeant King. How can I help you? What's your name?
I requested a reasonable accommodation.
Okay.
Numerous occasions.
Yeah.
Under ADA and the California Persons with Disability Act.
Yeah.
They refused to grant it.
Okay.
Or provide any assistance. You're already aware of what transpired.
Yeah. Hey, first of all, I just want to say thank you for your service. I understand you're a veteran, right? You are, right? Just want to say thank you for your service, okay? And we're here to help you, okay?
No, you're not.
Yes, we are. We're here to
Let
help
me tell you what. If
Okay.
that was the case,
Yeah.
your officers, the way they conducted themselves, that's unequivocally clear. I got put in cuffs because I called 911.
Okay, because you needed help, correct?
No, I needed help for them to leave at the time. First of all, when they came and knocked on the door, I let them in.
Okay. I'll tell you why the officers responded, okay?
That point, it's not a point to why they responded.
Okay.
It's in terms of the actions, sir, I requested medical attention. You are a supervisor.
And they're
I
coming-
have a disability.
And they're here now.
I have cervical, the positioning of this cuffs is exacerbated.
Well-
I've had for numerous occasions.
Right. What position are you talking about?
My right side, I told him cervical radiculopathy, C5 and C6. And
What do you want to do with
I
the
just
right
asked him, could I move this cuff from this position? The arm from this position, could stand in this position.
To what position?
The restriction of the arm being back here.
Yeah,
like
to move it to what position, though?
I need it to the front.
Oh, we
They
can't do
said
that per our policy. We can't do that
Okay,
based on
well,
our
that's the
LAPD
whole
policy.
thing about the Americans with Disability Act of California Persons to make an exception to a policy.
Already there.
So what?
So put him in
display-
You
handcuffs.
didn't let us finish our
What you
investigation.
mean?
Florida v. Ryer, 460 U.S. 491, 1983. Silence or refusal to engage with law enforcement does not justify detention or arrest.
So here's the deal. How much time do you have on?
20.
I have 34. So the smartest thing's going to be put him on a gurney, handcuff him to the rails, take him to the hospital, tell the doctor he's complaining that he's got previous back injuries and he fell in comfortable position with us, and you can get it cleared. That way it takes all the liability off of you guys, takes it off the city. I think that'll be the best thing to do.
Sounds good to me.
Okay.
We got
So we're on the same page.
This conspiracy against Douglas's rights, involving Wheeler, Yabana, and Sergeant Andrew Kang and EMTs, who openly admitted that their unconstitutional actions were solely to protect the LAPD officers and the city from liability, constitutes a flagrant abuse of authority under the color of law.
They started, doing the little racist, discriminatory stuff, so I asked them to leave. They didn't want to leave, I called 911. They detained me. They saying I'm on a 5150 hold. They saying I'm on a 5150 hold. So if I'm on a 5150 hold,
A 5150 hold is a life-saving mechanism meant for genuine mental health crises. In this case, it was weaponized as a tool of retaliation, intimidation, and punishment, used to unlawfully and coercively detain and arrest Slade Douglas because he dared to assert his rights and stand up for himself. The officer's actions amounted to an abuse of authority, kidnapping under 18 U.S.C. Section 1201, federal law, and California Penal Code Section 207, state law, and prosecutable federal civil rights violations.
then for calling 911.
Don't be telling everybody.
Douglas was not advised of his rights or allowed to notify anyone of his whereabouts.
You're going for an evaluation.
Hey, that way, this guy
Yeah.
gets taken care of. He wants medical help, he gets medical help, and
Yeah.
just, hey,
Yeah, and then they can just tell the doctor.
responsibility.
The principles established in Hope v. Pelzer, Rochin v. California, and similar cases make it clear that when state actors fail to safeguard against such deprivations, they cannot escape liability by merely passing the blame to other parties.
What a waste of resources as well. Taxpayers' money. There's people out there who really could use some police, a police president. Here you guys are wasting it on. Wow. What you were supposed to do.
course, Wheeler, Central Division. Hey, so I'm over here at Good Sam. He's in our custody, so he got transported because of his previous back injuries that he was complaining about.
Judge Maame Iwusi Mensah Frimpong, in her findings of fact, concluded, upon arriving at the hospital, Wheeler spoke with medical staff and Douglas received treatment without his consent. The officers' deliberate indifference to their duty of care, their collaboration in a conspiracy to evade responsibility, and their flagrant disregard for Douglas's rights set off a chain of causation that led to his brutalization at the hospital. At PIH Good Samaritan Hospital, a facility contracted by the city, the nightmare deepened as Douglas was subjected to a horrific series of abuses. Based on Douglas's sworn deposition, officers coerced medical staff into attempting to find something in his system to justify the arrest, resulting in Douglas being forcibly injected with drugs while handcuffed to a gurney, rendering him unconscious. Over the course of his ordeal, he was injected a total of 9 times. He was not just a man anymore. He was a victim, shackled in restraints, his limbs stretched out like a crucifixion. He was subjected to invasive blood draws, exhaustive toxicology tests, and brutal acts of sexual assault, including forced catheterization. His cries, his pleas for mercy, were met with cold clinical indifference and glee. For 8 excruciating hours, this relentless and dehumanizing abuse continued, carving deep wounds of trauma that no human being should ever be forced to endure. His body was violated, his dignity shredded. The sheer brutality of it defies comprehension, leaving scars that will forever haunt the soul. Once it was determined that Douglas had no drugs in his system, he was finally released from custody, without charge, and not as a free man, but as a broken one.
The City of Los Angeles, LAPD officers Jeremy R. Wheeler and Jeffrey H. Yabana and their lawyers Shakira Shepard, Thomas Harrell, have a defense strategy that uses defamatory language, betrays public trust, and affronts the principles of accountability and justice that are supposed to guide our government. Also by implying that the U.S. Constitution does not protect individuals subject to welfare checks and suggesting that exercising constitutionally protected rights indicates a mental illness, they undermine the very principles that safeguard all citizens. This defense is a dark echo of the Dred Scott ruling, denying basic rights to an entire class of people. Their defense fails to serve the public interest. In Town of Castle Rock versus Gonzalez, the Supreme Court ruled that police have no constitutional duty to protect, even with a restraining order, and cannot be sued for felony acts. Similar, in Warren v. District of Columbia, the court found no duty exists unless a person is in custody, meaning officers cannot be sued for failing to protect during wellness checks or justify a false arrest by claiming an obligation to protect the individual. I was essentially kidnapped from my apartment, subjected to forced hospitalization, drugged, sexually abused, and torture. And this is the things I get for honorably serving my country? Now more than ever, we must, as a nation, fight for the rights of our veterans and all victims of police brutality who represent countless individuals wrongfully arrested, accused, and abused.
At PIH Good Samaritan Hospital, records confirm that Douglas was subjected to violations of state laws, including assault with a deadly weapon, California Penal Code Section 245A1, sexual battery, California Penal Code Section 243.4A, assault, California Penal Code Section 240, battery, California Penal Code Section 242, false imprisonment, California Penal Code Sections 236 and 237, and a hate crime, California Penal Code Sections 422.55 through 422.6. The actions of the VA, in violation of the California Penal Code Section 148.3, along with those of the LAPD officers, EMTs, and medical personnel at PIH Good Samaritan Hospital, further constitute violations of federal laws, including 18 U.S.C. Section 241, conspiracy against rights, 18 U.S.C. Section 242, deprivation of rights under color of law, and 18 U.S.C. Section 245, interference with federally protected activities. The LAFD personnel and medical staff at PIH Good Samaritan Hospital acted as willful participants in a joint activity directed by LAPD officers, carrying out actions that shocked the conscience and subjected Slade Douglas to cruel and unusual punishment beyond the bounds of human decency. The VA, LAPD officers, LAFD personnel, PIH Good Samaritan Hospital, and the City of Los Angeles operated as a coordinated enterprise under the RICO Act, conspiring to violate rights, commit fraud, and obstruct justice. Such coordinated deprivation of constitutional rights is not just a singular act of corruption. It is a chilling reminder that no one is immune from becoming a target of systemic misconduct. When institutions entrusted with our health and safety conspire to exploit and harm, it poses a direct threat to every individual and to the public at large. Police violence doesn't only affect the victim, it also affects the family. Police violence has ripple effects, significantly impacting the victim's family member's health, causing it to deteriorate or leading to death. For example, heart attack, stroke, or stress-related illness.